Okay. Can everyone hear me? Okay. So welcome to the panel on content policy approaches and technical implications. My name is Liz Finberg. I'm the General Counsel for PIR. I'm going to give a brief introduction and then let our panelists do most of the work. The topic that we're about to discuss is very near and dear to my heart, and I would venture to say that the same is true with respect to many, many participants in the DNS and in our industry as a whole, including not only end users, IP interests, law enforcement, hosting providers, et cetera. Our panelists today represent diverse backgrounds and each have their own unique skills and perspectives, but they're here today to address this very common, the topic of common interest, and that's namely, first of all, whether and how content should be regulated, monitored, or otherwise addressed within the DNS. From both a technical and a legal or a policy perspective. So without further ado, I'll give a brief introduction for each panelist, and then panelists, I'm going to ask you to give a brief 5-minute presentation on your perspectives, anything of particular focus that you'd like to discuss today, and then we'll begin the discussion. To my right is David Abrahams. David is head of policy at Nominet. To my left, Christian Dawson, I2 Coalition co-founder and executive director. And to Christian's left is Chuck Tobin. Chuck is a partner at Holland and Knight. He heads the media practice there, and he is also well known for his work in First Amendment law. Full disclosure, Chuck is our outside counsel for court order takedowns at PIR. So, David, I'm going to ask you to kick it off. Give us 5 minutes on the topic and any area of particular interest you'd like to discuss.
Thank you very much, Liz, and thank you very much for inviting me to speak today. I think this is a really great event to bring people together outside of the ICANN process, because most of the people in here I see at ICANN meetings, and to be able to discuss some of the issues that are outside of ICANN's remit, quite rightly outside of ICANN's remit, but nevertheless are of common interest to all of us, whether we are running CCTLDs, GTLDs, whether we're hosting providers, internet service providers, or indeed whether we're in the IP community or in law enforcement. But I think that from the industry perspective, the interesting point when we come to issues of content, and particularly on illegal content, there is far more that we have in common than actually divides us. So it's nice to drop the any pretense of competition or competitiveness that we might have in the ICANN environment and work together here. Some of you will know that since 1996, Nominet has been the registry provider for the .uk top-level domain. Some of you will also know that Nominet is now a leading provider of back-end services to generic top-level domains as well. We therefore have to address issues like illegal content in two quite different legal and contractual environments, both as a CCTLD and as a registry for GTLD and GTLDs, and a provider to the registries of GTLDs. And if those issues didn't keep us busy enough, Nominet is rapidly expanding into new areas like cybersecurity, the Internet of Things, dynamic spectrum management, which, like all aspects of technology, bring new takes on the old story of content control and illegal content. So the good news from my perspective is there's plenty to keep me busy, there's plenty to keep my team busy, and I think there's plenty to keep all of us in this room quite busy for a number of years to come. Now, on illegal content. I'm very concerned that the priorities of the internet industry are being distorted by the political and economic concerns about intellectual property crime, rather than being focused on disrupting other more harmful types of online criminal activity. Now, please do not get me wrong. I'm not arguing that industry players shouldn't take appropriate action to tackle intellectual property infringement. Indeed, at Nominet, we have an award-winning dispute resolution process that allows rights holders to take action in a low-cost manner. Last year, we resolved about 728 disputes in .uk domain names, and we estimate that that saved around about $9 million in legal fees. So alternative dispute resolution can really be very effective. We also at Nominet act in response to notifications from UK law enforcement agencies. We produce an annual report on this, and in our last reporting year, we reported that we voluntarily suspended over 3,800 .uk domain names, which were reported to us by law enforcement authorities as being involved in criminality. Now, for me, the interesting point comes when you look at a breakdown of those figures, of those 3,800 suspensions. More than 92% of them came from the Police Intellectual Property Crime Unit, which does exactly what it sounds like. In contrast, only 3% came from the police agency which tackles online fraud. And we received only one notification from the National Crime Agency, which is the UK equivalent of the FBI and deals with terrorism and organised crime. So 92%, 3%, and just one. Now, these figures come at a time when we know, all of us in this room know, that organised criminal gangs are more active than ever in using malware and botnets, ransomware, a variety of online tools to extort money from businesses and from consumers. In the UK last month, we had the publication of the official crime figures. Those figures had doubled from one year to the next because for the first time they included 7 million online crimes. So in that environment, I can't help asking why it is that we receive 35 times more suspension requests from the police unit that deals with intellectual property crime rather than the one that deals with online fraud. Is that a fair reflection of the priorities of the police and law enforcement in the UK? I think we also have to ask whether this kind of disruption activity of suspending domain names actually reduces the level of online crime. But ultimately, the question that I want to ask, and I think the question that these numbers pose for us, is are the commercial interests distorting the priorities in the fight against organised crime? And I think that's a question that we all need to consider, whether we're in the industry or in law enforcement. And I'd love to hear what everyone in the room thinks about it.
Great, thank you. Christian.
Thank you. I would like to start my 5 minutes by giving you a little bit of my origin story. If my life was a comic book, this would be sort of issue number 1, because it has to do with the intersection of the DNS and commerce that has led me to speaking at a place like the DNS Forum. I have been in the internet industry since 1995, but it has been in the web hosting side of the industry. And about 4 years ago or so, I was running a web hosting company. It was one of the small business entrepreneurs where my clients had my cell phone if anything went wrong in the middle of the night. Of course, I had a tech support staff, and I got a call from one of my biggest customers on Thanksgiving morning, and he said, "Your techs are a bunch of idiots. My site is down, and they're telling me that the government took it." And I was like, "That's crazy. What are you talking about?" And I went to the site, and it said, "This domain seized by authority of Immigrations and Customs Enforcement." And I said, "Wow, I know nothing about this and the procedure for this sort of thing happen. I have no clue what to tell you or what procedure to follow, who to talk to, and how to get you your website and your livelihood back." The reason that I had been passionate about being in the web hosting industry for years is that I really like working with companies to help people with a dream to go and build that dream and develop something cool. As an example of the types of cool things that our company did, we helped build Etsy. I built Etsy's first cluster. this industry was doing cool things. And I was like, wow, this person just had his livelihood ripped away from him, and I have no clue what to do. So I started doing some research, talked to a bunch of people. We had a partnership with 2 Cows for selling domains. And so one of the people that I called up for advice was Elliot Noss, and he said, why don't you come out and check out ICANN? Come to the meeting. We've got a meeting coming up in Toronto. Make that your first ICANN experience. I'll introduce you to some people. And I went there, and one of the things that frankly terrified me was that it was filled with IP lawyers. That's fine, like that, but it was.
You say that like it's a bad thing.
Right. But there was nobody like me. There was nobody like me at all. I mean, I saw some people that were doing web hosting in addition to being a registry and a registrar, but I was a small business web hosting provider. There was a small group of ISPs, which I guess could be considered, they're also intermediaries like me that don't have contractual relationships with ICANN. But for the most part, we didn't have people that were talking about the needs of the intermediaries for whom discussions about how content specifically should be dealt with in the domain level should be had. And so I kind of ran back to my, now I had sort of like spent some time trying to grab all my friends and saying, hey, we should form a group, which ended up becoming the Internet Infrastructure Coalition, who's one of our sponsors today. And I said, hey guys, we need to come together. We need to be a part of these conversations that are going on because we're really, really not right now. One of the things that we have done in trying to get involved in internet governance conversations and ICANN conversations have been in part to try and talk about where these conversations should be had. And here's the thing, I think that a lot of things around content, the conversations are being had at ICANN because it's the one place where people in this industry are convening. The web hosting industry doesn't have a central organizing body and probably shouldn't. But when I hear the web hosting industry being talked about at ICANN, we are being vilified. We're being talked about being how irresponsible we are. Well, as somebody who was in that industry for 20 years almost, I can say that me and everybody that I worked with in that industry, and there's always outliers, we were responsive and responsible when dealing with obvious illegal content and engaging in areas, and a lot of content areas are in this sort of niche, in which it is not obvious what it is you need to do in order to comply. So now we focus on how to get the rest of the ecosystem involved in the conversation, where the conversation should generally be being had around content. We talk about how we can build more efficient relationships with law enforcement and how we can build more efficient methods of abuse reporting so that things that need to be get taken down more easily. But we're also advocates against solely focusing the content debate on things that happen at the ICANN level, because it's definitely not where it should be.
Thanks, Christian. Chuck?
Sure. I'll preface my remarks with 2 qualifications or 2 explanations. One is, to pick up on your theme, if my life were a comic book, I'd want to be Deadpool. If you haven't seen the movie, you should see it. He's on the surface, people think of him as an evil guy, but he's really trying to do good and enforce the law at heart. And second of all, since, as Liz disclosed, I am public interest registries outside counsel for enforcement issues, I thought I would add my comments, although we overlap in our views. That's why they hire our firm. The comments you're going to hear today are largely my own view of the issues that I've been invited here to talk about. So I've been practicing law since before there was an internet. I'm an old-time United States media First Amendment lawyer. I cut my teeth working for journalists, litigating cases. I was a journalist for the New York Times, the Washington Post, people like that. So I came at the internet steeped in largely a First Amendment, free speech has to get out. Free speech is the ultimate higher end in the United States as part of our culture, as part of our education, particularly in an election cycle. It's an appropriate thing to mention and talk about. And so I came to internet practice with that approach, with the additional training I received in law school on the importance of the American notions of due process. And due process, simply put, is the process one is due when you come in contact with a legal issue. And that chiefly means notice, an opportunity to be heard in court if you want to be heard, and a clear and understandable order from a court that has appropriate jurisdiction over you if the court is going to order you to do something. And so I came to the internet environment writ large kind of with a very heavy overlay of these important legal concepts. And I'm here to tell you, and I'm pleased and proud to represent clients like Public Interest Registry, who largely hire our firm to make sure those issues are managed and maintained while they are trying to be compliant with the law, good corporate citizens, and contributing to the health and growth and vitality of the next generation and the generation after that of international, global, and national communications media. And so just in thinking about how to explain how that plays out in my world, we see these issues come up in a lot of different environments. I'm spending much more time now advising internet clients of one sort or another than I am the old line print and broadcast, or at least the internet components of a lot of my traditional stable of clients, in addition to people who are doing new and interesting things to push the frontiers. And the places we're seeing that, some examples are subpoenas. We're getting a lot of subpoenas for our clients, particularly the content hosts, for the identities, the IP address, information about the providers of content from law enforcement, mostly from civil litigants. Garden variety example is there's a car crash out here on Pennsylvania Avenue. The Washington Post takes an entire card of film on it, and a year later when somebody litigates over that car crash, they want the Washington Post's entire digital file, or they want the freelancer's digital file, or they want the IP address of the person who put up on the Post website that information. Well, in the United States, we have a very strong spirit of anonymity, of protecting journalists' resources, of protecting sources of information. Those of you who were paying attention to the issue 10 years ago, a New York Times reporter named Judith Miller went to jail for 83 days to defend her right to keep a source anonymous. And so we spend a lot of time sorting those issues, and we've made a lot of precedent around the United States in grafting that whole principle onto the internet, making people show their case. So in a defamation case, you can't just sue a John Doe or a Jane Doe and then subpoena the internet host. You have to prove you actually have a case that has merit and that has met the qualifications for a defamation case to move forward. My friends at RIA know that similar issue has been applied in the intellectual property context by federal courts here in DC as well when they've litigated the issue. If you're entitled to the information, if you can establish your case, establish that you're not creating any greater incursion in the First Amendment than your legal rights require to vindicate your legal rights, the court will order my client to turn over the information. And in most instances, my client, after it's exhausted its appellate rights, they'll comply with that. So anonymity on the internet, subpoenas, is and remains a huge First Amendment and due process issue for us, and we're seeing a lot of that. Another way we're seeing are through the takedown orders coming to third parties, content providers like, or content hosts like Yelp, like Ripoff Report, like the other places, TripAdvisor. I just flamed, by the way, somebody, a resort in Virginia Beach that I stayed at. And so if you go look at TripAdvisor, you'll see why I did that. But the whole issue of prior restraint, we call them prior restraints, an order to a content host to take down materials or to refrain from publishing materials going forward. That's a huge First Amendment problem in the United States. The leading case on that came out of the Vietnam War. It's called the Pentagon Papers case, where somebody stole out of the Department of Defense's safes material. His name was Daniel Ellsberg, and he leaked it to the New York Times and the Washington Post, and it showed that President Nixon was lying about the body count in the Vietnam War. And the United States Supreme Court held that the Washington Post and the New York Times could not be restrained from publishing that information because the First Amendment, if it stands for nothing more, stands for the rights of journalists to decide what to publish. So that's another big area that we see and we're continuing to deal with in our media practice. And then the particular problems that we're seeing in the DNS space and in other people in your area really come down to a few issues. One is jurisdiction. Does the court that is issuing the order have appropriate jurisdiction over the registry, the registrar, whomever? Number two, did the person even bother to get a court order? Or are they simply sending a letter thinking that a registry, just to pick an example, is going to be the adjudicatory body to decide whether there really is copyright infringement or whether there really is counterfeiting or whether there really is defamation? And our role is to explain that it just doesn't work that way, that you have to have an adjudicatory body come in and make those decisions for you, and then we will, on the back end of that, come in and evaluate and advise clients of their rights on that issue. And then finally, there are still a lot of knuckleheads out there, to be kind to them, in the plaintiff's bar, the claimant's bar, who do not understand how the internet works, and so court orders will come in that literally people in this room could not understand and would not be able to follow. And in those instances, we get engaged either in a dialogue with plaintiff's counsel in trying to understand it if it's close enough to intelligible, or we make them go back to the court and fix the issue again, militating that due process has to control even when you do have a legitimate claim. So those are the main issues that we've been seeing over the years.
Thanks, everybody. Really good stuff. So I think I want to focus on a few things that were common to everyone's comments, and we're just going to begin at the beginning. David, you talked about, you used the phrase illegal content, and my question to you and to the panel in general is, do you believe that there is such a thing as illegal content per se, or alternatively, is it the way content is used? Because that really gets at the notion of due process and where you go for your remedy, and really what the problem is. You have to identify the problem before you can identify the remedy. And then, as Chuck points out, you have to understand the DNS to understand how that remedy can be effectuated within our industry. So I'll open it up. David, any thoughts?
Yeah, my first thought is I'm not a lawyer. And I say that in my defense. Is there such a thing as illegal content? Yes, I think there is. I think that there are certain categories of material which are illegal and should be illegal, and I don't think there would be any disagreement from any reasonable person in the room. The obvious example that springs to mind, and it's a terrible thing that these debates always come back to this, is child abuse content, and that's somewhere where I think the UK has led the world, quite frankly, in terms of the industry getting together at quite an early stage of the internet and saying, well, this stuff is just not right. We're not going to stand here and say, no, go and get a court order. And we're not going to stand here. You know, if we can set up a system of making sure that if that is genuinely illegal content, then we can get it down and we can get it down quickly, then that's what we're going to do. That's what the Internet Watch Foundation does, which is an independent, it's actually a charity set up by the internet service providers, by people like Nominet and others. It was actually set up in 1996, same year that we were established. And that is very effective at taking down content which is very, very much illegal. And I don't think anyone would have any problem with it being taken down and taken down quickly.
So really, I think that the responsible way to answer this question is to say that as intermediaries, your responsibility when something is brought to your attention is to figure out the answer to the question of, is the person who is utilizing the resources that I provided to them, in the situation that's been called to my attention, are they allowed to do that? And the answer is generally yes, no, or I don't know. There are very few circumstances in which yes is evident. I don't know is generally way more evident than yes. We talked about child pornography. There may be situations where we can go and we can say it's pretty obviously yes in a few more cases, but they're minimal. When I take a look at a copyright violation that's been brought to my attention, there are a number of things that I need to know to validate that claim that I don't know and can't know. And so the only responsible action is to engage in a process between, our client and and that obviously sometimes needs to go many chains, client to client to client, client of a client of a client of a client, to try and close the loop on that complaint, because you cannot be judge and jury for a situation in which the answer is I don't know, and most of the cases that we reach are I don't know cases.
I would add to that even the judges and juries don't always know, and that magnifies the complexity of the situation. We know that child pornography is illegal in the United States. We know that because a case called United States versus Ginsburg was litigated all the way up to the U.S. Supreme Court circa 1967 or 69, and the justices had no problem saying child pornography per se, it's illegal. But we also know that there was a statute passed by Congress a few years ago that made it a crime to lie about receiving war medals, to say falsely that I was a war hero. And a man named Mr. Alvarez was prosecuted and won a case in the United States Supreme Court 2 years ago, U.S. v. Alvarez, that he had a First Amendment right to lie about whether he received a war medal. So that criminal statute, as applied to Mr. Alvarez, was struck down. So we have a real complexity in the United States of criminal codes with a heavy First Amendment overlay. And if the courts can't figure it out in the first instance, how is a DNS provider going to be able to figure it out when they get a letter from counsel?
I wanted to add one more thing, especially because I said mean things about IP lawyers before, that I want to make it very clear. It wasn't supposed to be mean. I wanted to make it clear that a lot of the cases where I said the answer is I don't know, a lot of the cases it probably ends up that the answer is yes, even though we can't be the determinants that the answer is yes. The content industry does have real problems that they really need to address. And I'm all for discussions about how to make the processes that go through the right channels, all for conversations that make them as efficient as possible, so that we can try to get at the right answers, as long as it doesn't put us in the role of judge and jury.
Yeah, David, I wanted to ask you, you mentioned you have an ADR process, and that's something that we're looking at right now at PIR. Can you talk a little bit about what sort of due process measures are embedded in your ADR process?
Sure. Can I just start at the end of the last question and come to that, which is, how do you decide whether to act when you're notified on something? Our approach has been to trust in the authorities who are there to judge those things. Now, in the US, that's much more about a court and getting a court order. In the UK, it's generally more about law enforcement agencies being able to give a clear indication that something is a problem, and us avoiding any liability that we might have should we not act, having been told that.
Ask a question just in context
Yeah,
of
sure.
that. In our process, a law enforcement officer has to go before a judge,
Yeah.
generally, and receive a warrant or a subpoena or a summons or an ex parte where nobody else is represented, but the officer goes in, gets sworn in, makes certain statements to make a prima facie case for counterfeiting, piracy, or some other issue, and then the judge issues process. Under your system and under your regime, is the court involved, or is it directly from law enforcement?
No, it's directly from law enforcement. But it's only with certain law enforcement agencies that we have reached an agreement on in terms of what level of evidence they will act upon and provide to us, et cetera, before we agree to take it down. And if they if they don't continue to follow that process correctly, then we won't continue to accept suspension requests from them. The extreme in that example is child abuse material, where you've got the Internet Watch Foundation to do the checking, because if someone says to you, I think this website has child abuse material on it, it's illegal to look at it. You can't do anything. The only thing you can do is send it to for us, the only thing we can do is send it to the Internet Watch Foundation and ask them to look at it and tell us whether it is, and then we can act upon it. So we do not, as the registry, try to set ourselves up as the decision-making body. We are the tool of the decision. And then there's two, and before I get on to ADR, let me talk about due process in a suspension case. People can obviously appeal against suspension. When that does happen, and there's relatively few cases of it, because generally people are, the cases that come to us are actually genuine cases. We don't get a lot of false positives. If the registrant says, well, no, we issue them with 48 hours notice. If they challenge it at that point, we send them to the law enforcement agency to sort it out with them. On a number of occasions, what can happen is that the registrant can change their behavior, and the law enforcement agency will then drop the suspension request. So I think that's a bit of a win-win in actual fact, because you then deal with something which is problematic content, and you don't infringe the registrant by taking down their site. To move on to ADR and dispute resolution, yes, we have a lot of due process in that. I think that there's something that I find quite interesting about our dispute resolution service, which is we offer a free mediation service ahead of before it turns into a formal dispute. So if you feel your rights are being infringed by a domain name on .uk, you have to go through a process of putting in quite a lot of evidence and that sort of thing. That is sent to the registrant of the domain name. They get to put their evidence in response. We then have trained mediators who try to mediate between them. We have a 60% success rate in mediation of our disputes. So those 728 disputes I mentioned, they are the ones that went beyond that. But 60% of the cases that come to us get resolved in mediation, which is very effective, and normally means that people can come to a resolution about these things in a nice, easy, low-cost way. After that, it goes to an external expert. These are all very competent IP lawyers, and they will. There is a set of rules and interpretative documents about the rules of the dispute resolution process, and that sets out what decisions they're empowered to make. They make those decisions. There is also an appeal process within that, etc. But we don't, as Nominet, make the decision. We outsource that decision to a third party.
Thanks. I think I want to move on to the concept of intermediary liability, which is always on the horizon and always seems like there's always a push to expand it, at least in the U.S. And I want to ask you, Christian, do you find that there is a common understanding of who is an intermediary and who and I think, Chuck, I know the answer to I think I know what you're going to say, but we often find that the folks that write to us asking for action really have no, either they don't know, or they do, and we're just the most effective, the most blunt instrument to achieve the desired end.
Well, that's sort of what I was trying to allude to in my opening remarks, that I saw at ICANN an environment in which everybody was there. And so it was easy to pressure registries and registrars to try and take content issues at the level of their contractual relationship with ICANN. The thing about intermediary liability that's difficult to talk about is that different intermediaries do have different responsibilities. The responsibilities of registries and registrars are to their contractual relationship with ICANN and to the jurisdictional law that they've, of where it is they're located. I come from the cloud world. The registries and registrars, the naming and numbering system points you to a place where content is eventually stored, and we've got different responsibilities. Here in the United States, where I operated, in my cloud companies, it was the DMCA. There are things that I don't love about the DMCA. I would love to see some changes. I'm more comfortable personally with the notice and notice system in Canada, but it's what we have today, and there's not a great political environment to change the DMCA to something that is going to be better at the moment. So I'm an advocate for making the DMCA a positive and efficient process in the cloud community to make sure that cloud providers fulfill their responsibility as intermediaries. The protections that you get as intermediaries under the DMCA in the United States give you immunity for knowing what's on your servers, basically, as long as you take quick and responsive and practical action once something is brought to your attention. That is something that not everybody who operates a cloud company knows, because it is an environment where because you don't need to contract with a large body in order to become a cloud company, you can set one up in your basement or your dorm room. That it takes a while for people to spin up, and you sort of need to get to scale maybe until you figure out all of your obligations. Then that does cause problems. But I do not know many cloud companies, if any, that succeed without being responsible citizens and without engaging people in the proper legal ways.
Do we have any questions? I want to just pause here and see if anybody...
Good morning. My name is Peter van Roste. I'm the General Manager of Centre, the Organization of European CCTLDs. I think Christian touches upon something that has been on my mind for the last 15 minutes of this panel. That is, the panelists very eloquently describe the due process that they're applying. But we always start from the assumption that the intermediaries are somehow the guardians of the fundamental rights of their end users. What we see, I think, these days quite often is that from a commercial perspective, this is no longer true. And lots of, in particular, over-the-top providers take a very commercial perspective. First of all, from a cost perspective, every customer that, or every case that they have to deal with and that involve their intermediary liability is probably a customer that they're never going to make $1 or €1 on for the rest of that customer's loyalty. But secondly, from a commercial perspective, it also makes sense to be able to show the world that you're going further than just the statutory limitations, checking due process, waiting for court orders. And they're actually much more lenient towards third-party complaints. We also see this in the GTLD space, where an initiative like, Healthy Domain Initiative, is moving away, I think, from some of the legal lines of defense that CCTLDs have been holding, and GTLDs have been holding for the last 2 decades. So I think I would appreciate if the panelists could reflect a bit on how the commercial players in this field are moving the posts in this debate, and whether there are actually any limits as to how far they should be able to go in adapting their contractual terms and conditions to get rid of all this due process and get rid of all these costs that every complaint would bring to their business. Thanks.
I have a response to that. These things are true, and they actually don't concern me. Remember I said the answer is generally yes, no, or I don't know? In some areas, what we're doing is we're getting better about the I don't know. There are instances where we can determine repeat offenders of certain things, we can suss them out, and we can go ahead and take care of that situation. There are some situations in which content, the kind of content that we're talking about, is spam, is malware, is DDoS attacks, and we're finding ways to mitigate those types of things and cut them off before getting some sort of request to do those. So that's just a question of using technology and the advancement of our industry to limit the number of things in which the answer is I don't know and moving them into the yes category. The other thing that I will say is I have no problem with individual companies testing different ways to deal with these types of issues. Independent organizations trying to figure out how in an environment when we're still sorting out what being a responsible citizen on the net really is, testing out certain things is fine. And seeing how they work, seeing how the market responds, seeing how the rest of the community responds. Where I start to have a problem is when things that go beyond our legal lines of defense start getting codified in ICANN contracts.
Thanks, Christian. You raise a very good point, and I heard two things: the cost, to the person making the complaint, right, and also the sort of cost-benefit analysis that a commercial company might do in deciding, do I voluntarily comply with this request, and let's say it's a request for a suspension or a takedown. And I want to ask Chuck to weigh in because I think. Again, he and I work very closely together on a lot of these issues, and I do find that there's often a misconception within the community, the commercial interests, in particular IP interests in the community, that complying with court orders is just a completely cost-free proposition for a registry and a registrar. We often are told, well, you have to do that anyway. And I do think certainly that's true, but if we're going to harken back to the last panel and talk about an ethical approach, I think it matters not only that you comply, but how you comply and what measures you take to really ensure that you're fair, that you're balanced, that you're following the law, and respecting the rights of both who's ever complaining and the registrant. So Chuck, could you weigh in?
And I think that puts a very good finger on the difference in the two different, whose commercial interests are we really focusing on here? For me, it's always obviously going to be the client who pays my law firm to take care of their commercial, to take care of their overall business interests. And if in their business interests they want to develop procedures to compromise or expedite, that's their board, their business decision. But as Liz said, you can't underestimate, whichever way you go, the cost that a company has to incur, whether it is filtering voluntary compliance or filtering through court orders, which most of them do now. The orders come in. The orders usually start off with the first phase being a suspension of the domain in some fashion or another. Sometimes the orders, as I said, are clear and comprehensible. Sometimes they are not clear and comprehensible. Sometimes they are not from courts with appropriate jurisdiction. Sometimes they are from courts of appropriate jurisdiction. So there is a cost of compliance under the existing regime that any DNS service company has to go through. And then there's the follow-up, which is once the domain is suspended, and part of the problem is the solution of due process, because then the claimant has to go through the next step and demonstrate to the court entitlement to the transfer or to taking ownership of the domain. And that then requires a separate process to go through. And again, those orders come in a variety of jurisdictional saliency, comprehensibility, and all of that. And so there is a cost that is already borne by the DNS community in complying with this. I would love to be in the room when there's a discussion about what an alternative to that would look like, and to see if there is one that provides the rights, the First Amendment rights, the commercial rights, the dignity rights, however you want to characterize the rights, to the registrants of the world out there, and then balances that out against things. I'm hard-pressed just in hearing the discussions I've heard to find one that balances everybody's rights appropriately and takes into account the cost factors. I do think, to the extent that the community is talking about the issue, it's a healthy thing. You've been doing it for 20 years. Even before that, it led to things like the DMCA and the CDA, which I personally think are marvelous operational mechanisms and modes of operation, and have given rise to internal policies and practices at a lot of companies that have worked very well, at least in the United States.
David?
So I think that we were talking about the .uk alternative dispute resolution process, and I was just thinking it does tick the boxes that you were setting out there in terms of protecting the rights of both sides. It's been upheld when cases have been appealed through the courts, etc. as well. So it's a good, robust system. But equally, it's still not scalable to the level of IP infringement that we see around. And so I agree that the problem is not, to my mind, the problem is not necessarily process, but scale.
And if I could also interject, part of it is cultural as well. I asked you a question earlier about police not having court intervention. That's a basic level issue for us here in the States. I understand, having worked in the UK quite a bit for The Guardian and other publishers over there, that the law enforcement mechanism works differently in interacting with the civilian population, but it's really largely a huge cultural difference, as are the privacy regimes and the interplay with the First Amendment, and the subject matter, I believe, of one of your other panels today. They're not insoluble problems, probably, but they're very difficult ones culturally to overcome in any kind of an ADR mechanism.
Sorry, go ahead.
Well, I was just going to say, I think that's absolutely right. The UK has more trust in governance and authority. We even trust our spooks quite a lot, because we think they're all James Bond. No, I couldn't possibly comment. But and I think that culturally that's very different to the US, and as Byron said earlier, the idea that the law is there to protect the citizen from interference from the government, it's coming from the different end of the telescope. But I wanted to say something about Peter's question, if I may, which was are people competing to create safer environments? I think they are. In the UK, we could just insist on everybody saying it. We could keep on pushing back. Would have a few problems, but we could keep on pushing back and say, get a court order, get a court order. But what we would end up with is more fraud, more malware, more IP infringement in the .uk space. That doesn't suit us. That's not what we want as a company that wants a vibrant registry. I'll stop talking now.
Well,
Thanks,
what I wanted to do was take a moment to jump on a discussion that you talked about scalability, and I wanted to use that to try to figure out how we can have a conversation about how we can create a situation that is more scalable than the one we have now. In doing so, I wanted to make a shameless plug for a mailing list that actually we put together to discuss this very issue. Drew from the Secure Domain Foundation, his organization and ours at I2 Coalition have put together a mailing list that's focused on trying to take all of the various groups that are working on standardized abuse reporting and figure out which ones are being successful, try to figure out how we can get some way for standardized inputs. Because until we have a situation in which people are sort of funneling things in the same way, it's going to be really hard for any situation to scale and for us to be more efficient at takedowns, whether they are takedowns with merit or without.
Thanks. Any additional questions from the room?
Thank you. If we have enough time, thank you. It's so Anne-Marie. I'm IPIT lawyer in Europe and member of the advisory council of PIR. So my question is about the involvement of all the technical providers against the infringing operator or website, because we have more and more judge ordering blocking access to some providers at a level or another level to help, for instance, to fight against counterfeiting. And then we see that without the cooperation with all the technical chain, it's very difficult to be efficient, or they change their domain names and they reopen. So I would like to know to what extent you think it's a good thing that the technical world is, the trend is to involve more and more the technical providers to protect IP, to protect content. So this is a first thing. And what do you think about this trend? And the second question is about Brexit. In the focus of what you are discussing, we have a lot of directives to apply. And do you have already some predictions about what might happen with the Brexit? Or will you say that we don't know yet? Thank you.
Okay, I'm going to let Christian answer the first part of the question, and I think the second part of the question belongs only to you, David.
So I think that what you were saying about the technological difficulty of dealing with a situation where people are going after the providers saying we're going to block content at the domain level, it perfectly indicates why we need to take this conversation down to the cloud level and engage in how we are dealing with the most effective processes that still have due process of law to deal with content at that source. The fact of the matter is that my client who had the blog and had his domain taken down, his livelihood was very much affected. But that day, he went out and did create a variant of that domain name and tweeted it out to his followers, and that was an easy way for him to continue that process. So from my perspective, it shows the sort of futility of trying to deal with things at the domain level.
I think that's right. I want to follow up on that point. I did ask that question at the beginning. Is this disruption activity actually having an impact on the level of online crime? Are fewer people being ripped off because of the disruption? Is less IP being infringed because of it? I'm not sure that anyone's come up with a kind of cast iron bit of evidence to back that up. But I'm struck by the fact that all the law enforcement teams who we talk to in the UK are talking about disruption, not capturing, not erasing from the internet or anything like that. They are talking about disrupting organized crime because they know that as soon as they are playing whack-a-mole, as I think you say over here, and as soon as they hit one thing, it comes up somewhere else. So I don't think that's sustainable long term, and I think that we as the industry are probably better placed to come up with good workable solutions to how we address that in a scalable manner than law enforcement and regulators and politicians, because they don't tend to get those things right. Talking of not getting things right, Brexit. Can you see how I voted? I have made a mid-year New Year's resolution to not predict anything about UK politics anymore because I'm wrong. But me and most of the rest of the Westminster bubble. The effect of Brexit, don't know. is the short answer. But I cannot see how, as a country outside of the European Union, but right there next door to the European Union, with a very significant amount of business going between us and the European Union, we're not going to end up having to comply with most of the directives that we already comply with. And you know, the situation is that European law has been part of UK law for 40 years. The process of changing that is so big that no one has actually worked out how to do it yet. Because I'm not going to go into the details of it, but it's complicated, and we don't know how it's going to be done. So my expectation is everything will hold, and then there will be certain bits that get opted out of or changed, or you know, as we go along. But quite frankly, I wouldn't bet any money on it at all, because it's completely unknowable at the moment.
Yeah, we're right, actually a little bit over time, but I wanted to get to the last couple of questions.
Hi, my name is Vicki Scheckler. I'm with the Recording Industry Association of America. I've been with them for almost a decade, and most of that time has involved dealing with voluntary initiatives and how to deal with various groups that work in the internet intermediary space. So thank you so much for this discussion. As always, there are lots of areas of agreement and disagreement. I'd like to take a couple of minutes just to talk about the areas of agreement. We agree with you that copyright infringement continues to be a significant problem online. We agree with you that practical solutions are the way to go. We agree with you that there has to be responsibility and stepping up on all sides of the fence, including ours. And we have worked with a variety of intermediaries in these last 10 years to set up processes and systems in place to try to solve these things practically in a low-cost manner that thinks about due diligence, that thinks about due process, that thinks about the First Amendment rights of individuals, thinks about the privacy rights of individuals. And we have learned a lot over this process. We stand ready, willing, and able to work with everyone in this community about those as well. In terms of your questions about, do we know that domain suspension makes a difference? Yes, we do. I've seen it happen. I'm happy to share that information with you offline anytime you want. In terms of IP and DNS blocking, in your country, there have been studies about the efforts in your country that show it has made a significant impact. ITIF, which is an association here in the United States, put out a paper in August about the impact that those systems have had there. Not quite the same as voluntary initiatives for suspension of domains directly, but analogous. It is worth something to consider. So we look forward to working with all of you and all of you in the room. I'm happy to share any data that we have with you, or to talk about your systems and how we can work with your systems. Thank you.
Thanks, Vicki.
So I think that's standing willing to engage is fantastic. That's, I think, what it's going to take. If the truth is that a lot of us in the room think that solving these problems is not something that should happen at an ICANN level, we can't have ICANN direct these kinds of conversations. They're going to have to happen in rooms like this, where we get content and law enforcement and industry, all parts of industry throughout the ecosystem, together to try and figure out how, in a conversation, be it lists, be it conferences, we can sit down and try to make progress together. And it has to be that kind of willingness to be open and engaged. I appreciate that.
Thanks. One last question.
Okay. First question and then some thoughts. Question would be to David. I was wondering how you deal with liability, as we as registry can only act on a second level. You're taking down a domain name on a second level. You are in a position where you may take down services that are really legal, that are representing perfectly fine businesses, and if you act on any hints of your local law enforcement agencies How do you deal with liability if you're taking down on their advice? That would be really interesting for me to know. That was for the first part. The second part, actually, I'm wondering whether we are not fighting a proxy war we may not win if we act on content. To give you some examples, we are currently dealing with jihad websites, and we try to take them down as far as we can, acting on incorrect data. But guess what? We just done it, and then they are coming up as a variant on a different space. So shouldn't we tackle the problem where the problem really resides? And the problem resides with those guys who are hosting this service or providing this service. So does it really make a difference if we take down? I'm not so sure. Even in those cases, to make it even worse, if we are looking at phishing issues, for example, you really need to act very, very fast to get the damage in limitations. But we just can't do that. It takes a lot of time to act on due process, like one of the panelists says. And if we act on the due process, then the damage is almost done.
Okay, so in response to the first question, I repeat, not a lawyer. I'm not a lawyer, so this is not going to be a legally perfect answer. But I don't believe we've ever faced any kind of liability issue for taking down for suspending a site on the request of law enforcement. So I don't think, and we've done a lot of them. So I don't think it's an issue right now. Fair enough. In response to your point about evidence, the UK communications regulator, Ofcom, did a number of studies around IP infringement around the time of the new laws being introduced to try and crack down on online copyright infringement. What they found is that people who used file sharing websites and things like that were by far the biggest consumers of legally purchased intellectual property compared to everyone else, which was a kind of fascinating insight, I think, into the user base. These people were spending more on legal content than they were in terms of, or not necessarily than they were in terms of infringing, but they were spending more than the rest of the population. The one effect that we have seen in the UK of the court orders that you mentioned, where there's IP blocking and DNS blocking and things like that for things like the Pirate Bay, etc., is a remarkable expansion of people's knowledge about VPNs. And pretty much any kid in school can now tell you about that. Not necessarily about illegal content. It's probably just to get past the filtering that they've got in their school.
I want to circle back to your question because I definitely agree that a lot of these conversations should be had at the web hosting level. When I was running my web hosting company, we worked very proactively with law enforcement to try, and when we were complying with legal requirements of a takedown, to do so in a way that minimized or eliminated collateral damage from legitimate businesses. But it's sometimes very difficult. It's very hard. What we end up being faced with ultimately as we engage in this discussion industry-wide is a situation that at the end of the day is going to continue to be very hard. You had mentioned that there are ways, some websites are trying to figure out how to block content based on their own accord. I think of Facebook and Google that have started building more technology so that they can figure out how maybe a few more of the maybes that should end up being yeses, to go back to my analogy before. When we have this discussion industry-wide, though, we need to be very careful because in the same ways that we discussed needing to have solutions that scale, they need to scale down. Because a solution that gets dealt with for content needs to be accessible to the person that I talked about before who's creating their cloud company in their basement or their dorm room or the middle of nowhere. That's the only way that the internet as we know it stays free and open and competitive, and we get the next technologies in the door that are going to change the world even more. So this is going to ultimately end up being a hard question with hard answers. I often end up pointing my law enforcement friends, and I engage very closely with law enforcement and work with them diligently. They hate it, but my favorite quote is from the movie Touch of Evil, and it is the only place in which police work is not hard is in a police state.
That seems like a good place to stop. I think that's a pretty tough act to follow there. Well, thank you all. This has been a really fascinating discussion, and thanks to the room for your time and attention.